All right, good afternoon, everybody. Welcome to today's edition of Deep Bench Briefings put on by Falcon, Rappaport, and Berkman, defusing contract landmines before they blow up your deal. Always better to take care of this before it blows up your deal, not after. I am Kyle Lawrence. I'm a partner with the Corporate Securities Group here at FRB, and I will let my two bejacketed co-hosts introduce themselves as well before moving forward. So, Mr. Berkman.
Hello, everyone. Thanks for joining. I'm Jeff Berkman. I'm the co-chair with Kyle of the Corporate Securities Group at Falcon Rappaport and Berkman. And since my name's on the door there at the last end, I'm obviously one of the founders as well. Thanks for joining, and we look forward to spending time with you on this webinar.
Thank you, Jeff. Mr. Alex, say hello if you can.
Oh, I am muted. My apologies. I'm supposed to be the tech guy here. I'm running the show.
Off to a good start.
My name is Alex Migliorini. I'm an associate in the corporate department primarily. I've been heading a lot of the AI efforts here at the firm, so that's just something that I'll be peppering in throughout the presentation today. You know, the context of how AI might come into play. Thanks all.
Excellent. Thank you, Alex. And just a general reminder, today's presentation is meant for informational purposes only. It is not meant to be construed as legal and or tax advice. Do not rely upon this presentation as being set in stone. Obviously, every contract is unique, just like a snowflake. So just make sure that if you have questions that arise based on something we said, don't assume that what we said during this presentation will automatically apply to your contract. Please feel free to reach out to us if those questions arise. So now that that's out of the way, let's get into what we're going to talk about today. The general topics we're going to focus on over the next hour are about contract drafting. One of my personal favorites is the boilerplate myth, why standard language is never standard. As far as I'm concerned, the word standard doesn't exist. There are things that are commonly done. There are things that are market, but at the end of the day, your contract is yours. You are not bound by what somebody did last week in their contract. It's a very important distinction that I run into constantly over the course of my 20 years of practice. We're going to go over some contract landmines that typically blow up deals, drafting with precision. We'll get into some examples of that later on. We're going to focus on indemnification, specifically where vagueness gets expensive. This is something that comes up. Any of you who have ever worked on a merger or an acquisition, you know all too well that the representations and warranties and the corresponding indemnification sections are probably the most important and most heavily negotiated sections of those agreements. So we're going to focus on those to make sure that you don't inadvertently trip over something that causes a problem for you and or your client. We're going to get into some case law that dives into where nebulous drafting meets the courtroom and certain problems that have arisen due to, carelessness or what have you. We're going to focus on non-disclosure agreements, drafting traps in the most common deal document, because we've all seen NDAs, and they are probably the most underwritten and under-negotiated documents, so problems can certainly come up there. And of course, we have key takeaways and best practices as well, which we'll focus at the very end. I don't see a window here where people can ask questions. I always say, I don't want to listen to myself drone on for the next hour, but if you have the ability to ask questions, go for it. But I don't see how you can do that. But I'll let Alex, the tech guy, figure that out. So
Maybe in the chat. The
maybe in
chat.
the chat. Yeah, I guess that would work. Yeah, I guess that makes sense. I just didn't see it opened up. There we go. All right, the boilerplate myth. So I have one rule as a practitioner, and Alex, having worked with me for the past 5+ years, knows this very well. And that if I give you a starting point to work with and say, okay, drafted a contract using this as your starting point, and I'm reading it and I'm reading your work product, and the company is based in New York, and I see in the document it says governing law, Florida. And I say, associate, why Florida law? Oh, that's what the document said. That's what you gave me. I will lose my mind, as should you. There is no such thing as boilerplate. You have to read these things. Every word in that document needs to specifically apply to your specific situation, because every boilerplate clause carries legal significance and should be tailored to the specific transaction. Even the stuff in the back of the agreement, it is all important. It is all legally binding upon you and your client. So it's very important that you read them and make sure that they are bespoke. Courts routinely enforce boilerplate provisions as written before a coroner's rule. We'll get into that. And careless drafting can have serious and expensive consequences. Any of you who have ever been involved in a litigation, you know the only people who win typically are the lawyers, not the clients. So to avoid reinventing the wheel and to create efficiency, people generally use boilerplate language in many types of agreements, including ones that we're going to go over today. Master service agreements, consulting agreements, operating and shareholders agreements for your entities, asset purchase agreements and stock purchase agreements, your M&A deals, and loan documents, promissory notes, security agreements, pledge agreements, things like that.
Yeah, and I think today we're going to be probably centering up because we could spend, many webinars going up through the ins and outs of all these agreements. We'll probably be focusing mostly on the MSAs here, the Master Services Agreements, just because it's something that is very central to a lot of businesses, especially if there are a lot of executives who are in attendance today. It might be something that might be helpful. But yeah, I mean, we're gonna go through all these.
Fantastic. Thank you, Alex.
Of course.
You can go to the next slide, please. There we go. A typical contract clause is what you're going to see in most of the contracts that you work on. The preamble and the recitals, obviously, who are the parties, why are we here, the purpose and scope of the contract, what the services are. If you have a master services agreement, you're going to have a statement of work in the back, or work order, comes in various forms, but that's going to be in most of your contracts. You're going to have payment terms. How are we getting paid? Do I pay you by check? Do I pay you by wire transfer? What if the agreement doesn't say anything? I don't know. Indemnification, confidentiality, non-solicitation, term and termination. How long is this contract for? How do we get out of it? Excuse me. AI consent, which is something I'll let Alex talk about when we get to it. Representations and warranties. We're going to talk a lot about that in a later slide. Data privacy, which is a very important topic and one that we as a firm have a special focus on. If you have, if you handle information on behalf of your clients, personal information, personal health information, for very different forms of it, you need to make sure that you are complying with all of the state laws and federal laws that apply to this. Or if you're going overseas, you need to know about this stuff. Just assuming that what's in the contract you have applies to your situation, you are just walking into a trap. Those are per occurrence liabilities. So be very careful with that. We'll talk more about that in a bit. The limitations of liabilities. What is the extent of my obligation to repay you if something goes awry? And exclusivity. So I know we're moving quickly, but we're going to get into more detail on these things.
Yeah, and I just want to just highlight, a few of the things here. We addressed indemnification and the confidentiality provisions throughout the slides in much greater detail, but just some of the ones here that I think worth, that merit further mention is really say at first, the purpose and the scope. I mean, first we need to ensure that the contract actually matches what the business deal is. Often you'll see that the actual paper doesn't reflect the actual business terms, and it's important to read through it and make sure that what is written in the agreement is what is actually the business deal and what the business terms are. Because as Kyle mentioned earlier, the four corners rule, the courts are going to look at what's on the four corners of the page. They're not going to look at what you guys discussed in email beforehand. So it's most important to just make sure that that scope actually does reflect what is actually happening.
Yeah, and I'll jump in on one thing here. The reason we included all these is, for the most part, you will see them in every agreement. I've taught law school for many years, and particularly in contract drafting. And one of the things that I tell, fledgling lawyers is contracts tell a story. And there's typically a story that needs to be understood, and the structure will follow that story, but it's the number of the these provisions that you will constantly see, and that's why we refer to them as standard by virtue of only being the fact that you will see them often, but the intent and the need to review them carefully is what the focus has to be on. So it's not unusual to go through a contract and be able to just off the top identify that these provisions are going to be there, but you know the need to actually read them and make sure they say what you want it to say. We can't stress that enough, and we will certainly several times today.
Kind of the MO of the day.
Right, right. This is again, I think Kyle really drilled it into me. It's these forms or things that we've done in the past. They're merely starting points.
That's all they are. Good job. You win.
There you go. And I think just one thing I wanted to highlight on payment terms and AI consent, specifically with payment terms first, is a lot of people will just get focused on what the actual price is, but sometimes they miss what the actual mechanics of how payment is made. Is there a right to review or accept work product before payment is made? Is it going to be net 30? And these are all dependent upon how the deal is structured. If there is milestones set forth in a statement of work, then this might change. And this is really why boilerplate language doesn't always work, because you have to read through each of these in every deal just to make sure that they actually do reflect, again, what the business terms are and not what what the form says. And some people think, hey, there's language in here and it sounds pretty good. It must be correct, and I don't want to tweak something or change something if I don't understand the full significance there. But that's why it's so important to go through these and actually make sure that you understand it. If there's something you don't understand in an agreement, these should be written in plain language, and you should question why are they there if it doesn't. It probably doesn't make sense in context of the entire deal if it's just an outlier there. And another thing on just AI consent, because I'm an AI guy and I have to talk about AI. This is going to be the newest addition to the list here. But really the question is there consent to use AI? Are you consenting to the other party using AI? If you are providing them with proprietary information, do you want them putting it into a large language model that potentially trains off that information? Do you want assurances that they're using enterprise LLMs, large language models? Is there, there's things that need to be addressed, and there's nuances here, and we'll start seeing these more and more in contracts. We certainly have been putting it in as a matter of course, but we're going to see it, happen over the next year or two, because it's becoming so pervasive and an inextricable part of, I think, all business dealings.
That's you hit the nail on the head. It's going to be very prominent in all our businesses if it's not already. I'm gonna jump ahead 2 slides if you would, Alex. Yeah, we'll go over this. So here are just some examples of easy traps to fall into in the back of your contract. We've all seen a contract that has a choice of law. It determines what state's substantive law governs the disputes. Obviously, this is US based and it gets international. It's a whole different ball of wax. But if you have a contract between a party in New York and a party in California, which state's law is going to govern? This is an important point of negotiation that comes up in every M&A deal that you'll see. The one I see all the time also is, where are disputes going to be adjudicated? Courts in the United States, that's ambiguous. Guess what? There's a lot of courts in the United States. Are you gonna litigate in family court in Illinois if there's a dispute? I mean, that's applicable here. So you need to be very specific, and you need to know what your client's appetite for risk is. If your client is, maybe they don't care, or it's crazy, but if they don't care, it's not going to be something you're going to dig your heels on. But if you want home court advantage, you need to be mindful of that when you're drafting these contracts. So you also want to be specific as to using the right language. We have a slide later about the differences between the word shall and may, which is a very important distinction that can swing wildly. So you have to say, if there's a dispute, it shall be brought in this court, not it may be brought in this court. If you say may be brought, that doesn't mean anything. Jeff, I saw you come off mute. I'm sure you've had an instance in your career where this got missed and you end up litigating in a far off land.
Well, I can tell you, there's a story I often tell when I'm discussing this and trying to drill this into new associates and young associates and law students. Is years and years ago when the internet was just fledgling and people were preparing terms of use and privacy policies before they even knew what that meant. A fairly well-known company, a very well-known company, apparently just cut and paste their terms of use from another
Ugh.
website, which was kind of a common thing. And actually, we see that happen a lot today, where people think terms of use and privacy policies aren't important, but that's another problem or issue. And when they copied it, they didn't realize that the forum that was chosen in the governing law had nothing to do with either of the parties. And as a result, or any of the parties, like their clients, their customers, or whatever, and where they were located. And as a result, the judge looked at it and said, you chose a forum, you chose a governing law, that's your problem. The customer happened to be from that particular state, and they were stuck in a state and in a under a governing law that wasn't appropriate and didn't make sense for the company because they weren't based there. So, this again, for the 10th time, will belabor the point. You have to read these clauses. Too often we hear people refer to things like the miscellaneous at the end of the agreement as boilerplate or miscellaneous because it comes at the end of the agreement. And like I say a lot to people reading these, just they get tired. People get tired of reading these long documents and think, oh, they all say the same thing. But it's just you really can create a problem and find yourself in the soup if you're not reading these. So pay as much attention to these as you do to any other document, clause or provision or words in the contract you're reviewing.
Yeah,
No.
that's exactly right. And to that point, oh, sorry, Alex, did you want to throw something in?
Yeah. I was just going to just chime in about the miscellaneous provisions in general and just highlight, if you ever selling your business, these contracts are all going to come under review, and a lot of these provisions are reviewed in the due diligence process. So, a potential buyer is going to inherit these contracts, and if they're poorly drafted, they can create a lot of issues in the M&A process and the sale process, or it can also, devalue some of the assets if these things are drafted in a way, because they're going to be inheriting these agreements and they're really not going to have the opportunity to renegotiate.
It's a great point. Before we move to the next slide, I just want to harp on one point here about dispute resolution. Again, while it's important to pick the location of where the disputes are going to be adjudicated and determined, you also want to designate the process by which it's adjudicated. Are you going to court? Are you having an arbitration? Is there going to be mediation? It's important to think through all of those scenarios and make sure you pick one that's applicable. We're all corporate guys. In 20 years, I've been to court twice, and I have no intention on going back. I don't want to go to court. I'd much rather have a mediation. It's cheaper and theoretically faster. Doesn't necessarily mean it's better, but it's important to think through what's best for your client in this situation. Let's jump to the next slide, which has, I think, more examples of this. So integration clauses, you want to make sure that the written contract represents the entire agreement and there's nothing else extraneous or outside the four corners of the document that's going to be binding upon the parties. If you don't have that language and you have a non-binding letter of intent that has different terms, or you have an email saying, oh yes, I agree to this, well, then what controls? You can really step into some thick soup if you don't have that kind of seemingly simple, innocuous language in the back of your agreement to make sure that it's right. Force majeure clauses, acts of God, things out of anybody's control can impact your performance. Hurricane comes through, wipes out your manufacturing facility. Now you can't deliver on the supply agreement. You should be absolved of liability for a period of time until you can right the ship. But it's important to think about the world we live in today. 10 years ago, force majeure clauses were largely limited to natural disasters and things like that. We didn't have COVID and government shutdowns and pandemics at the top of mind. So if you're looking at a contract You think about, okay, what's something that can happen that can limit my exposure? You have to think about the world we live in and update those provisions accordingly.
Yeah,
Excuse me.
one where I'll jump in here quickly because focusing specifically on COVID and where we've seen the force majeure clauses change. Not only do they, mention pandemics, which had been there for a while, but they mention specifically now government orders because it wasn't so much the pandemic that was always the problem in terms of contracts, but the government orders that shut down the ability of people to operate. So, you know proving whether a pandemic exists or not, because it actually came up as an issue where some countries were saying it wasn't pandemic and others weren't at the beginning, but clearly there were government orders that said you cannot operate. So thinking like Kyle said about, the specifics and the nature of where we are. I mean, today government orders would include tariffs, right? Like things like this will have a dramatic effect on companies, and you need to think about what the exact language is and just not rely on, language that has traditionally existed for years in these clauses.
One thing I really want to focus on before we move on to the next section is the notice provisions. And this might be the ultimate example of what we're talking about how there is no boilerplate. Because contract says, okay, if there's a problem, Alex and I have a contract and I'm supposed to deliver something and I don't deliver it, he's supposed to tell me that. Well, how is he supposed to tell me that? Does he pick up the phone? Does he shoot me an email? If the contract says in order for him to deliver notice, he has to send it via an overnight carrier such as FedEx or UPS, but he sends me an email instead, well, guess what? He didn't deliver notice to me. So you really need to think through these kinds of things. It sounds simple. It's a really easy thing to gloss over. Like Jeff was saying, you can get tired by the 60th page of your contract, but that 60th page is just as important as the first page. And you can really step on a landmine by not paying attention to the details and things like that. Just looking at the time, I want to jump ahead to, I want to start getting into some of the landmines, the blow up deals. The costly comma, grammatical ambiguity. A bad example, the agreement applies to citrus, organic fruit, and vegetables. Good example, this agreement applies to citrus, organic fruit, and organic vegetables, but the comma right there. It is unclear if organic applies to only fruit or to both fruit and vegetables. Another example I have, which maybe slightly less professional, but you'll definitely remember it, is let's eat kids versus let's eat, comma, kids. Those are two very different sentences, and I promise you'll all remember it now. Put that comma in there. Good example is Oakhurst Dairy, which ultimately paid $5 million in settlement after the First Circuit ruled that a missing Oxford comma in a Maine statute left overtime exemptions legally ambiguous. Imagine picking up the phone and calling your client and tell them they owe $5 million because you didn't put a comma in the contract. Details matter. Very, very important to focus on these things.
Let me just jump in on the details matter because,
Please.
the one thing I'll say about this is, and Alex actually mentioned it, there's a concept called the parole evidence rule. Courts are not going to look outside the four corners of the documents if the language is clear, and particularly where there's sophisticated parties. So a scenario came up in a corporate merger or buyout where it was a multi-billion-dollar transaction, and there was a typical requirement in terms of clearance with competition board and et cetera. What antitrust rules, and the parties had language in there that basically required notice if someone wanted to exercise because the clearance was taking longer time. So it was very simple. You had a right to do it. And what they had done is that, one party had a conversation with the other and they agreed orally to go ahead and extend it, but they didn't put it in writing. And the notice provision said it had to be put in writing. And the court said, too bad. I'm not going to allow this to be seen as enforced or complying with the notice provision because of the fact that you put something in the contract and it's not my obligation to revise it. It doesn't matter whether you now see it as meaningless because you actually had notice. The actual notice requirements said what this contract said, and I'm not here to reinterpret it. The judge said so. This concept of like, yeah, the comma's out of place, and we really know nobody meant to eat kids. Obviously it's an extreme example, but courts are going to look at the four corners and what's in it, and they're not going to revise it unless there's absolutely no other choice or ambiguity or vagueness. So take that to task and think about that when drafting or reviewing agreements.
Right. I'll jump in here on this one. Um, I feel like this is the concept of shall versus will versus may. So, I mean, this is the epitome of when words really matter, right? It's not just stylistic at this point. This is these dramatically change the actual meaning of what is being said. So in the bad side here, we have that the buyer shall have the right to inspect goods and shall notify the seller of defects. Now, on the good side, we see that the buyer may inspect. So they have the option to. There's no burden or obligation upon the buyer to inspect the goods, and that the buyer shall notify. So then, again, mandatory. So these types of words that are used throughout these types of provisions, they really, really make a difference. And I feel like, tweaking these minor things, it seems like a very minor red line if you change shall to may, but it has a very, very large impact. Um, I don't know, Kyle, Jeff, if you have any further input on this one.
An example that I had of this, it was with my prior firm, and it was a deal that I had closed before I had arrived at the firm. But basically, it was a dispute over a networking capital calculation, and the agreement simply said, I'm assuming that everybody here watching at least knows roughly what that is, but the agreement effectively said that at closing, this is the amount of networking capital that the seller has to leave behind. And then afterwards, the buyer will, has the ability to reconcile. And what it said was, when the buyer reconciles it, it may deliver a statement to the seller showing its calculation of the net working capital. And it didn't do that. It just exercised its offset right. And the seller, which was our client, came in and said, well, wait a second, you didn't tell us what happened. And the buyer said, I'm not contractually required to do that. And they were right. Now we ended up settling because that was a bad faith argument, but that's what the contract said. So think of just the amount of time and expense that the client had to undertake paying lawyers to solve that dispute, which could have easily been fixed with just some careful editing at the outset. It's just we can't harp on it enough how important that is. Okay, let's move on. Indemnification without a defend, remedy gaps. And this is something that comes up all the time, and we can probably spend a lot of time on this. So on the bad side, party A agrees to indemnify party B for any third-party claims. Well, that's not vague. On the good side, party A shall defend, indemnify, and hold harmless party B from and against any and all third-party claims, damages, losses, costs, and expenses, including reasonable attorney fees, we'll get to that part in a bit, arising out of or relating to this agreement or this situation, not just anything under the sun. Um, so indemnification, just for people who don't know, indemnification means when you have to go out of pocket to pay for something that the other person did, whether it's a judgment or a settlement or IRS claims, whatever it may be. It doesn't force you to hire lawyers and fight the lawsuit on the other party's behalf. We'll get to some of that in a bit as well, but it just creates the obligation that you're going to reimburse somebody for that.
Yeah, I
Jeff,
recognize it's kind of like insurance, right? Like, and this is another sort of teaching point, but breach of contract that's between party A and B to the contract is just a breach of contract claim. It's not indemnification. Breach of contract where party C sues, your client party A, or you get drawn into a lawsuit, that's when you go against party B for indemnification. So like these are two separate concepts that people sometimes have trouble understanding is the difference. Probably, hopefully everyone on here kind of gets that, but just want to stress that because it is an important distinction.
it's
And
also, oh, sorry, go ahead, Alex.
nope, I was just gonna just highlight that on the bad side we have it just says agrees to indemnify. And on the good side it says defend, indemnify, and hold harmless. All three of those things, while they sound very legalese, have very different meanings and have distinct protections. So it's important to keep those in mind when you're looking at these. We always ensure that it is fully addressed But defense is that they would have to defend them in the case of a lawsuit if they got sued and there was an indemnification covered whatever the suit was. And indemnification would usually concern reimbursement for losses.
Yeah, I mean, just as a point of, sort of a fun fact that people might not realize, we often see these like couplets and triplets in contracts, and sometimes people are like, "Well, what's the point? Right, title and interest or whatever, acknowledge and accept and things like that." Sometimes there are actually scenarios, and here's where many of them came from. You had the English law, and then you had the French invade England and change the law to all these French terms. And then people got so indoctrinated and used to these French language terms for the same language legal concepts that they became part of contracts where you do see the scenarios, that there's actually two or couplets or triplets. So often those just mean the same thing. This is an area where there is a distinction, holding harmless and the ability or the right to or obligation, I should say, to indemnify versus defend arguably has a difference. Right title and interest, may or may not, depending on, most IP lawyers will see that as different. But, agree and acknowledge, not so much. So when clients yell at you, or if you're on the opposite side and you're yelling at lawyers saying, can we shorten this thing because we got, a lot of extraneous words? Hopefully the lawyer's thinking through the ones that are, key, and there's a distinction like here, as opposed to, hey, this is how we do this all the time. And we have a hard time sort of self-regulating ourselves and deleting and not having extraneous provisions where it's clear.
Yeah. An ounce of prevention is worth a pound of cure. That extra page in your document might spare you millions of dollars in exposure, the way I view it.
Right. So like when someone says, I want a short agreement, it's like, well, which rights do you want to give up here?
Right, exactly. I could spend 3 hours talking about that, but sadly, we don't have that time. All right, let's go to the next slide, please. Sorry, you have the con.
So I think we have vague material breach here.
Mm-hmm. So either party, on the bad side, either party may terminate this agreement immediately upon a material breach. That's sufficiently vague, and what's a material breach? Reasonable people can disagree as to what that means. On the better side, the good side, either party may terminate this agreement upon written notice. We talked about notice before, FedEx versus email or what have you. If the other party, A, fails to make a payment within 30 days after receipt of written notice, so you're supposed to pay me, you didn't, I send you a notice, that starts the 30-day clock. The other party files for bankruptcy or becomes insolvent, or C, fails to cure any other material breach within 60 days after written notice specifying the breach in reasonable detail. Putting aside that 60 days might be a long time, that's a good way to codify it. You're supposed to perform under this contract, you didn't do it. Here's written notice sent via FedEx saying you're supposed to do these 3 things, and you have now 60 days to do it. If you don't do that, now we have a much clearer path to declare a termination of the agreement and much less room for the other side to challenge it. If you simply just terminate the agreement on what you think might be a major issue, the court may not agree with you. And then you could potentially be liable for wrongful termination. So, again, I know we're repeating it, but it's important to think through these things. The colloquial, I can terminate if you don't perform, is not going to cut it if push comes to shove. You want to the extent you can, explicitly list specific trigger events that cause the automatic termination rights, or have defined cure periods or some mixture of those 2 things. And I've seen this become a problem. I mean, I can't tell you how many times. I mean, right down the hall, we have a whole group of litigators, sorting out this exact issue of performance under a contract. Very, very important. Glad I'm not in that meeting. Just laughing. He knows it's true. One more here under the landmines. I think there was one more. Yeah. So if you are liable, what is the extent of your exposure? Seller, I love this one. Seller's liability for any claim shall not exceed the total fees paid under this agreement. Any claim under the sun. You don't even have to do with this agreement. That's crazy talk. On the good side, on the better side, seller's total aggregate liability for all claims arising under or relating to this agreement, specifying what it is we're talking about, whether in contract, tort, which is personal injury laws or otherwise, shall not exceed the total fees actually paid by buyer to seller during the 12-month period preceding the year giving rise to liability. This is a very common mechanism that you see in service agreements. One party is rendering services for the other. There's a problem. I've paid you $500,000 over the past year. That's going to be the extent of your liability, basically returning the money that you've paid to me for poor service. The word any there is very ambiguous, as I demonstrably indicated before. It can mean the cap applies per claim or multiple claims or in the aggregate. Who knows? I saw Jeff came off mute. So he
Well,
does a lot
yeah,
of these types
I
of
was just going to
agreements.
say, like, just generally about indemnification, which will, I think we get to the slide eventually, but you know, there, the concept is important again about thinking about your particular contract and what, the potential exposures are, because there's the obvious things where you say, indemnify against breach of contract or whatever it may be, right? But there may be specific that are important. We generally include, which we get pushback often, like a breach or violation of a third party rights. Not only relating to intellectual property, which is always pretty much seen, but also thinking about this in terms of third party rights include like privacy issues, data security breaches, whatever. And so you need to really make sure that the scope, not only the exact words and with the coverage in terms of, what's allowed, but the scope covers beyond just the very standard. You will get these indemnification clauses that will be thrown in there that are standard and don't contemplate the actual potential exposure of if you're the, party concerned about this, the actual exposure. So think beyond what's offered. Is there something that needs to be in here to make sure that you're covered for the specific claims or potential exposure that can exist, or the risks of entering this contract? Um, Almost every one other point, because it's just so important now. The rise in the number of lawsuits relating to privacy and data security is exponential. It's one of the biggest risks facing companies today. So if you have are in the structure of an MSA, master service agreement, and you're receiving services from the third from the provider, the vendor, the tech, company, make sure that indemnification clause holds them responsible, not only in terms of a representation regarding privacy and compliance with applicable law, but that the indemnification clause, do not let them push back and say, we're not going to allow this. And we'll get to it, but since we're talking about liability caps, do not allow them to cap the liability of that. You can, it's in some cases it will, tens of millions of dollars with class actions that will just destroy a company. So, if you take anything away from that, next, these last 5 minutes, in addition to everything Kyle and Alex saying, please, note that anytime you're reviewing the indemnification clause of a contract.
I think we have a little bit more to go. Unless I
Mhm.
misread this lot, but that's okay. Now we're going to get into indemnification. We've touched upon it a few times already. It's just, as I mentioned earlier, it's just such an important piece of so many contracts that we work on, and it's where poor drafting will really come back to burn you and more specifically your client, which is worse than it burning you. So as we talked about, just a quick recap, indemnification provisions allocate responsibility for third-party claims and losses. When the terms are unclear, the entire risk allocation framework collapses. The parties can dispute whether the coverage extends to first-party losses or third-party claims. Undefined triggers leave obligations completely open to interpretations, which is the last thing that you want. You want your contract to be clearly defined as to who's responsible for what, when are they responsible for it, how do they have to satisfy their responsibility, so on and so forth. As Jeff just mentioned, absolutely, he's absolutely right. If you don't have a cap on liability, that's unlimited exposure. One of the earlier examples of bad drafting is, seller will indemnify buyer for any claims. If there's a tax claim that's worth millions and millions of dollars, I mean, that's if you sell your company for $1 million and have a $10 million claim, that's a problem. So you want to be mindful of things like that. Failure to define procedures for defense and settlement creates paralysis during claims, which is another problem. I mean, if any of you have been involved in litigation, so much time is spent waiting for things to happen, or you're involved in motion practice. All the while, you're not getting the satisfaction you need. You're not being made whole, and you're not moving on with your life or your business. You're trapped in this thing. I don't mean to badmouth litigators, and sorry if there's litigators here, but it's just the process really is the punishment. So nobody wants to deal with that. If you don't have a requirement for prompt notice, you can allow stale claims to surface years later. So what that means is you have a contract, you're making a representation about your business that you're selling. Well, how long does that representation survive after the closing? A day, a year, 3 years? Is it just the statute of limitations, which can be up to 6 years, depending on what it is? You can't put yourself in that position of being unknown. You really need to specify these things. And real estate contracts have them, they apply one way. Mergers and acquisitions are typically go another way, but it's important for you as the drafts person to be mindful of that so you don't think you close the deal, you go like this and you take your check and go out for the closing dinner, and then 5 years later a claim resurfaces that nobody's prepared for. I'm telling you, that's a terrible place to be as a practitioner. You don't want to do that. Pop down. Okay.
Yeah, and the essence of the indemnification of what it's really looking to stab at is to cover third party cases. So if there, say, you were in a contract, someone produced some sort of intellectual property or marketing materials, but then they infringed on someone else's content. So then you get caught up in this lawsuit and you want them to step in and say, hey, we'll handle this because it was our fault. We infringed upon this. And this is an idea that sometimes gets muddled in these agreements very often. Sometimes people use the indemnification provision as a way to enforce a contract against their counterparty, when really the crux of the indemnification is to seek recourse for when there is a third party claim. Someone who's not party to the contract sues one of the parties and it's the fault of the other, someone else's negligence or something to that. One thing that you always need to also consider here is to make sure that if the indemnity, the person who is getting indemnified, if they caused any sort of negligence or sometimes we'll use a heightened standard of gross negligence, willful misconduct, then it would be carved out of the indemnification provision. And that's important because if they are in some way responsible, that they shouldn't then be fully indemnified.
That's right. Thank you, Alex.
Of course.
We talked about liability caps. If there's no cap on the indemnification, you can have potentially unlimited exposure. You want to consider aggregate caps, a fixed dollar amount, a basket, like a deductible concept. Jeff used the example before that these are basically like your insurance policy. Think of having an insurance deductible in here before your indemnity obligation triggers. Jeff, did you want to add something?
Yeah, no, I was going to say this is the area where you will often see two types of caps. You'll see a cap on liability for just sort of general breaches, and we can talk about those in a bit because those are often part of the discussion, part and parcel of the issues that go on in a contract negotiation. But in most cases, we're going to push back on any kind of cap on confidentiality breach, non-solicitation breach of, applicable law or privacy, things where, again, those are just examples where a breach and under the indemnification provision could literally wipe out a party's ability to from a financial standpoint or just under the contract, the benefits of the contract. So it's imperative that you look at these and think about potentially two different buckets or two different types, like a super cap or no cap on certain of the indemnifications, while others may be more standard and the cap may be lower.
That's a great point. And down here on the bottom, we talked about notice requirements. And I want to spend a minute talking about this last bullet point, which says specify whether failure to provide timely notice is a complete bar or only reduces recovery. And this gets missed a lot in contracts that I see. Basically, what this means is, let's say I'm indemnifying Alex, and Alex has to let me know that something happened that gives rise to an indemnification claim. An employee had an injury, they slipped and fell. You need to make it right because it happened on your watch. But let's say he doesn't send me that notice for a period of time. And in that period of time between when it happened and the time when he tells me, the problem has become exacerbated. So is my indemnification obligation the initial damage? What about the ensuing damage that's effectively been caused by Alex's failure to notify me? So I always put in these contracts, a failure to notify is not a bar on recovery, but unless and to the extent that my failure to do so has caused it to increase in value. So just again, things to think about. You want to think through what these provisions say and how they can come back to bite you. And I think the next section is case law, but I actually want to jump ahead a couple slides to non-disclosure agreements, just because this is an important one. And I mentioned it at the very beginning that these are probably the most frequently executed document. I'm sure everyone here has signed one, and they are underdrafted. Um, they are typically something that people just dust off. They change the names and they hand them off without really thinking about what goes into it. Now, we'll get into some of the specifics in a minute, but Jeff specifically had a situation arise. Was it about a year ago, where it was
Yeah,
a
it's a couple of
very
years
important
ago,
client of the
but
firm. Yeah.
yeah, but basically, I think in all the years that, that I'm, practicing for many, many years, too many now, I think, approaching close to 40, but the the amount of times I've actually been involved with a dispute over confidentiality that resulted in litigation is all of one, which says something about like, hey, they've been, either really well drafted or thank God nobody, violated them. But the one was involved with, which went on for a number of years, literally had a provision about defining what the confidential information was, about distinguishing between confidential information and trade secrets, and making it clear that a violation could lead to a claim. And as a result of that, we prevailed on a summary judgment motion, and the prevailing on the summary judgment motion, has led to a very successful outcome. And it's an example of where clients, parties will sort of again read these things and say we see them all the time to say the same thing or whatever. But again, yes, there's a lot of standard language in here, but be sure to read them and make sure they're geared, that you may, confidential information as a broad term. And if there's something that is specific to the nature of the relationship, it's probably worth calling out, because you don't want to get into a fight as to what is confidential information or a trade secret. So you're going to see these often prior to a discussion or the beginning of a discussion between potential partners or between, potential contract parties, and you're going to see them again in the in the actual contract. Again, gear them toward the actual scenario and the potential risks of disclosure. There's, we could easily spend an hour talking about NDAs, but please be mindful of them, because they are not just standard provisions. These are, again, can have a huge effect on the business about the enforceability.
That's a great point, and it's it's such an easy thing to gloss over too, because they're typically short agreements, and the sort of rule we like to apply is they're only worth what you're willing to spend to enforce them. But in some of these industries, and especially nowadays with intellectual property being as valuable as it is, you really do need to be really careful of it. One of the things that I always like to look at is how do you define confidential information within the body of the document? So let's say you have a specific industry. If you're in a sales-oriented business, confidential information should include customer lists, business forecasts, sales information, marketing plans, things like that. If you're representing a food and beverage manufacturer, formulas, recipes, cookbooks, whatever it may be, branding associated with it, you really do need to think about it. To just say any information that I give you is confidential is not going to cut it. It's too vague. You also want to preserve attorney-client privilege, include language confirming that proprietary information that is given as part of a due diligence investigation is entitled to privilege protection, and that remains protected, and you can't just waive it by hand waving it away. Um, Alex, I saw you come off mute, and you work on a lot of NDAs for the two of us and for the department as a whole. Is there anything in your experience, you want to educate the folks on?
Absolutely. Yeah. I mean, I totally agree with the point that the confidential information needs to be very specific to the operational or the operations of the business. You'll see source code for, tech companies, things of that nature. So it's very important to get all that information tuned in to what the client is actually doing. And sometimes if if you use the boilerplate language, and you give it to a client and it has things that are just so superfluous or extraneous, sometimes the client may say, why is this even in here? This doesn't even make sense in the context of what I'm doing here. So sometimes you need to just look at things like that and make sure that if there's something that doesn't apply in a contract, it's better removing it than just leaving it in there because it can introduce ambiguity. Another thing I just wanted to highlight is, these NDAs, it's not a one size fits all. There's NDAs for employees. There's NDAs, for, when you're going into an M&A deal. There's, they fit all different types of circumstances and they'll cover different things. So if it is an M&A deal, you want to make sure that it's covering that the confidentiality protections extend to, that there is discussions happening, that there's terms under discussion, because one party could use the information that they learned to then leverage it against other buyers and things to that extent. So it's good to, also hone in on that and just understand what the purpose is that underlies the information that's being shared.
To It's a great point, Alex, and something you said really resonates with me because I had this when I was a younger associate, and you never want to be on the receiving end of this call, but making it specific to, you don't want to have things from prior agreements lingering in subsequent agreements. You mentioned things like source code. What I was talking about before, the definition of confidential information. If you're representing a tech company and your confidential information definition includes source code and the tech specific language, and now you're representing a sales organization, but you don't update the confidential information section, I promise you, I don't care who you are or who your client is, that's what the client will see. They will see a mistake like that and they'll know exactly what happened. So, one, yes, you also want to protect the client, but you also need to insulate yourselves and make sure that you and your firm are not inadvertently stepping in a landmine just because you didn't read the contract. So, very important to be very, very careful with those things. Clients, I'm telling you, they will see that 10 times out of 10. It's like they get laser vision with that. They don't see other things, but they see that. So be very careful. Okay, one thing that I just want to add here, this part about no warranty, when you deliver confidential information that should be provided as is, you are expressly disclaiming any reliance upon that information. Usually when you have an NDA, you're at the very beginning of the process. You're not even necessarily at the letter of intent stage. You're certainly before diligence. So there's just a limited amount of information that you're giving, but you're basically saying, look, this is what it is. We're not repping it. If you don't have that, the other side can potentially make the argument that, well, they gave me these financial statements and I relied upon them in agreeing to enter into this deal, and I spent $100,000 in lawyer fees trying to make this deal happen. And oops, turns out that their financials were completely wrong or heaven forbid fraudulent. You can have a breach of contract claim potentially if you do that. So little thing goes a long way in protecting you and your client from downstream issues. We can pop to the next slide, the few minutes we have left. Sorry. Okay. These are things we talked about previously in the presentation, just term and termination. How long does this obligation last? Is it forever? Is it only for 2, 3 years? Injunctive relief, I want to spend a minute talking about because this is something that I always do, and Alex knows that I harp on this. You see this a lot in contracts. The disclosing party should be able to seek injunctive relief to stop the other person from disclosing it. A lot of times it just says the disclosing party is entitled to injunctive relief. They have a contractual right to injunctive relief. No, they have a right to seek it. They may not get it, but we do not have the ability to just give them that right. You don't want to have ex parte actions without you in there. That's a big no-no. Add the word seek. It will go a long way in protecting you. You want to also include language permitting equitable relief without having to post a bond in exchange for that. Again, it's these little things that crop up in these agreements every time that people often gloss over. And as we talked about throughout this presentation, you want to have a limitation of obligations. The indemnification is important. What are the remedies? What rights do I have if you breach the agreement? What happens at the end of the contract? Do I get to keep the materials for record keeping purposes? Do I have to burn them? Do I have to send them back to you? All of that needs to go in the contract to be specific. With a few minutes left, Alex, do you want to add something on NDAs before we turn to the last slide?
I do. I do have something to add on the
Excellent.
AI front. Again, the one thing to be cognizant of when using, ChatGPT, Claude, any of these things is when you're putting that information into it, especially if it's a personal account or a free account, um, you might be violating NDAs, right? Because you're sharing that information with a third party, and that third party is training on that information. So it's really important to sometimes include a provision in there that says that they're at least using an enterprise model if you're okay with them using AI, or they have to obtain written consent prior to using it. And there's different guardrails you can put on it, but the general idea is that people are using AI and using it certainly can create damages or cause issues. If you're putting material non-public information into, a free account, then that can cause clear, damages and liability. So just a little note from the AI side of things, and just something to keep in mind when using all these new platforms, and make sure that you actually review the terms of service and understand what the training is on whether they're training on the content, whether they're using it for other purposes. What happens to your information, and it really dovetails into the whole data privacy aspect.
Great points. Thank you, Alex.
Of course.
I think we have one more slide, just kind of summarizing and wrapping it all up in a nice little bow. The boilerplate matters. Every clause should be tailored to the specific transaction. The answer, it was in the template you give me, is a fireable offense. Do not do that. Specificity prevents litigation. Choice of law, forum selection, force majeure, assignment clauses all require precise mandatory language. Indemnification is where vagueness costs the most. You want to define scope, triggers, caps, procedures, notice requirements, and of course, carve-outs. Representations and warranties are what drive indemnification claims. If you have unclear survival periods and materiality thresholds, it can break that mechanism and lead to a real problem for the client. And case law confirms courts will not rewrite your contract. Ambiguity is litigated. It is not resolved by judicial goodwill. That's a huge misconception that people have. I'm going to walk into court and the judge is going to decide with me because I'm right. No, that's not how it works. The cost of precision is always less than the cost of litigation. I like that line. Gentlemen, any parting words for our guests?
Yeah, I just has a couple ideas here. Look, literally, we could have had a webinar that goes on for hours because there's so much detail that needs to go into each of these provisions. Drafting with specificity, thinking through aspects of an agreement. So, for example, if it says a party has to do something, make sure there are time, periods in there. And it's clear things like, calendar days versus business days. If there are payment provisions, do they expect to be paid by wire or ACH or cash or whatever it may be? Hopefully not cash, but you get my point. So a lot of what we've discussed here is just the very high level basics of importance of these provisions, but be careful to read the provisions carefully and make sure that they're geared specifically to your transaction. And the other thing is, just because the other party gives you an agreement and it's a PDF and it looks like it's, standard, doesn't mean that you can't push back with comments. And then the last point, which is super important, is most vendor agreements, most MSAs will have embedded links to additional agreements that will govern, like terms of use and privacy and other things that, may apply specifically to the nature and the type of the service or product. You have to read those too. You cannot just, assume that those aren't important, because particularly in the privacy, this is where a lot of the issues will arise if they're not reviewed.
All right, well, that wraps up this edition of Deep Bench Briefings. Thank you, Jeff. Thank you, Alex, for joining me on this journey. And I hope everybody watching learned a little bit of something. And if you have any other questions or want to reach out to us, I believe, um, how will I do that? How will I get this? Can you? Yeah, there we go. Thank you, Thank you, Alex. Please feel free to reach out to us. We're here at your disposal, at your disposal. This is what we do for a living, so we're fluent in these types of contracts and all these provisions. So if anything seems out of whack, or you just have a general question, or just want to chat over a cup of coffee, please reach out. We look forward to hearing from you. Thank you for joining us.
Thanks, everyone.
Is that is that it? I guess so.
Yeah, that's it.
I guess so. I didn't hear anything from Nick. All right, awesome.
All right, good job.
Lunchtime.
Lunchtime it is. Back to you.